My sister showed up to probate like she was walking into a networking event. Not grieving, not cautious, not humble. She was in a tailored blazer, hair perfect, holding a thin folder like it was a victory lap. Her attorney walked beside her, already smiling, like the judge was just a stamp they needed. I sat on the hard wooden bench and tried to keep my breathing even. Warm and relatable truth. I wasn't nervous because I didn't know the facts. I was nervous because probate court has a specific kind of silence, one where people watch you like your entertainment. And my sister loves an audience. When our case was called, she moved first. Of course she did. She didn't look at me, not even once. She looked straight at the judge and spoke like her life had always been decided in rooms like this. Your Honor, she said, clear and confident, the trust is obviously mine. Obviously. That word always does a lot of work for people who don't want to prove things. Her attorney slid papers toward the bench without even glancing in my direction. It wasn't aggressive, it was worse, it was dismissive, like I was a technicality. The judge didn't react to her tone. He reacted to the claim. The trust, he repeated, eyes narrowing slightly. This matter is set for a probate calendar. Why are we here if the assets are in a trust? My sister's attorney answered smoothly. Your Honor, the petitioner is requesting an order compelling distribution and recognizing her as the proper beneficiary of the trust assets, he said. There are concerns the respondent is interfering with administration. Interfering. That's the word they use when they can't say existing. The judge's eyes moved to me, measured, not unkind. Ms. Carter, he asked, what is your position? I kept my voice steady, warm, human. My position is simple, I said. My father's trust has an executor and instructions. I'm following them. My sister let out a tiny, annoyed laugh. Oh, please, she said loud enough for the room. Dad told everyone I'd be the one to manage it. She's holding it hostage. Dry humor flickered in my head. Right. Because Dad's biggest wish was to hand his life's planning to the person who treats obviously like evidence. But I didn't take the bait. The judge looked at my sister. Ms. Walker, he said, I'm going to ask you one question and I want a direct answer. My sister nodded like she was ready for a softball. The judge asked, calm and surgical, do you have proof that the trust is obviously yours? My sister's smile held for half a second too long. Her attorney started to speak, then stopped. Because proof in probate doesn't mean vibes. It means documents. He tried anyway. Your Honor, he said, there were verbal intentions. The judge held up a hand. Documents, he repeated. My sister's smile tightened. He told me, she insisted. He said it. Everyone knows it. The judge looked unimpressed. Everyone knows is not a legal standard. He glanced down at the file, then back up. Where's the executor? He asked. A calm voice came from the first row. Here, Your Honor. A man stood. Mid-50s, plain suit, not flashy. Carrying a binder that looked like it had been handled by actual adults. The executor. He didn't look excited to be here. He looked like someone who'd rather be anywhere else but had prepared for exactly this. The judge nodded toward him. Sir, he said, state your name and role. The man did. Then the judge asked, do you have the trust instrument? Yes, the executor replied. He set the binder on the lectern and opened it with the kind of careful confidence that makes lawyers go quiet. He cleared his throat. Your Honor, he said, before anyone argues, I'd like to read one line. My sister scoffed. Her attorney leaned forward, annoyed. The judge gestured. Go ahead. The executor flipped to the last page, finger following the text like he'd memorized it. He read one line out loud, and my sister froze. Not angry, not offended, frozen, because whatever he just read sounded like a trap Dad left behind. The judge's eyes sharpened. Read line 12, the judge said, voice suddenly firm. The executor's finger moved down. He inhaled, and I felt the room tilt, like the next sentence was about to decide who walked out with power and who walked out exposed. The executor looked down at the page, then read it slowly. like he wanted every word to land exactly where it belonged. Line 12, he said, states, if any beneficiary petitions any court to compel distribution, remove the trustee, or interfere with administration without documented cause, that beneficiary's interest shall be reduced to $1, and the remainder shall pass to the other beneficiary. The sentence hit the room like a door slamming shut. My sister's attorney didn't move. My sister didn't blink. Even the judge sat back slightly, like he was absorbing how clean and how intentional that clause was. Then the judge's eyes locked on my sister. Ms. Walker, he said, calm and cold, did you just petition this court to compel distribution and interfere with administration? My sister's mouth opened. Nothing came out. Her attorney stood up too fast, chair scraping. Your Honor, he began, voice suddenly careful, we are not contesting the trust. We are simply seeking clarification. The judge held up a hand. The trust is clear, he said. It anticipated exactly this. Then he looked at the executor again. Sir, the judge asked, is Ms. Walker a beneficiary of this trust? Yes, the executor answered. And is Ms. Carter a beneficiary? The judge asked. Yes. The judge nodded once. He glanced down at the clause again like he was confirming it wasn't misread. Then he asked the executor, is that clause valid and executed properly? The executor didn't hesitate. Yes, Your Honor. It was part of the trust instrument, signed, notarized, and witnessed. I have the originals. My sister finally found her voice, sharp, panicked. That's not fair, she snapped. He wouldn't do that to me. The judge didn't react emotionally. He reacted like a judge. Fairness is not what I'm here to decide, he said. I'm here to enforce the document your father signed. Then he turned to my sister's attorney. Counsel, he asked, did you read this clause before filing? The attorney swallowed. We reviewed the instrument, he said. The judge stared at him for one long beat. So either you didn't read it, he said, or you read it and filed anyway. Silence. My sister's face flushed hot, then drained pale. She leaned toward her attorney and hissed, fix it. He didn't look at her. He looked straight at the judge because now he understood the cliff he was standing on. Your Honor, he said quickly, we would like to withdraw the petition to avoid any. The judge's voice cut him off like a blade. It's already filed, he said, and it's already been read into the record. He glanced toward the clerk. Mark line 12 as Exhibit A, he said. Mark the petition as Exhibit B. Stamp. Stamp. My sister flinched at the sound, because stamps don't care how successful you are. Then the judge looked at my sister. Ms. Walker, he said, your father didn't just create a trust. He created a deterrent. My sister's eyes went glossy, not with sadness, with rage. You're all working together, she spat, voice rising. The judge's eyes narrowed. Lower your voice. Then, with a calm that felt like ice. Do you have documented cause? He asked. My sister blinked. What? Documented cause, the judge repeated. Line 12 says, without documented cause. So I'll give you the opportunity. Do you have documents showing misconduct by the trustee or executor, mismanagement, theft, failure to provide accounting? My sister's attorney looked like he wanted to disappear. My sister glanced at him like he was supposed to magically produce a scandal out of thin air. He cleared his throat. Your Honor, at this time we do not have... The judge held up a hand. Answer is no. He turned to the executor. Have you provided the beneficiaries an accounting? The judge asked. Yes, the executor said. I mailed it 2 weeks ago. Certified mail. I have proof of delivery. My sister's attorney's face tightened. The judge nodded once. And have distributions been made according to the schedule? He asked. Yes, the executor said, withholding only what is required for taxes and final expenses. The judge turned back to my sister. So, he said, your claim is not that the trustee stole. My sister's jaw clenched. It's that you want it now, the judge finished, and you want it all. My sister snapped, because she doesn't deserve it. The judge's eyes flashed. That is not relevant, he said. Then he leaned forward slightly and asked the executor one more question, slow and deliberate. Sir, he said, does the trust name a successor trustee if the current trustee is challenged? Yes, the executor replied. The judge's gaze sharpened. Who? The executor flipped one page back, then answered, a corporate trustee, Harbor State Trust Company. My sister's face went tight. Because corporate trustees don't do favors. The judge nodded once, like he'd just found the lock behind the lock. Then he looked at my sister's attorney. Counsel, he said, you're going to explain to your client what line 12 means. My sister's attorney started to speak. The judge raised his hand again. No, he said. Not here, on the record. He looked at the clerk. Read the petition's requested relief out loud, he ordered. The clerk did. It was exactly what the title promised. Compel distribution, remove trustee, award full interest, sanction the other beneficiary. When the clerk finished, the judge turned to my sister. Ms. Walker, he said, that petition triggers the clause unless you can show documented cause. You've shown none. My sister's breathing changed, fast, shallow. Then she did what she always does when she's cornered by paper. She tried to flip the story into a personal attack. She manipulated Dad, my sister said, voice shaking. She poisoned him against me. The judge didn't flinch. Then you file a proper contest with evidence, he said. Not a bully petition for distribution. He looked at the executor. Sir, he said, I want the accounting and certified delivery proof submitted as exhibits. The executor nodded and stepped forward with a single sheet. Clean, official. One proof, visible, boring, lethal. The judge scanned it. Then his eyes lifted to my sister, and his tone shifted. Ms. Walker, he said quietly, you didn't come here to protect the trust. He paused. You came here to pressure the other beneficiary, and your father wrote line 12 to stop exactly you. My sister's face twitched. Anger, humiliation, fear, all fighting at once. Her attorney leaned in and whispered, we need to stop. She didn't stop. She said something too loud, too sharp, too revealing. Fine. If I lose the trust, I'll take the house. The courtroom went still. The judge's eyes narrowed. The house? He asked. The executor's head turned slightly, like he already knew what that meant. And the judge said slowly, Sir, does this trust hold title to any real property? The executor flipped to the schedule of assets. Yes, he said. And the address? The judge asked, is... The executor looked down, and then he said the address out loud. My house. When the executor read my address into the record, my sister's face changed. Not shock, because she already knew. It was more like satisfaction, like she'd been waiting for that moment. See? She said, loud, almost excited. That's what I'm talking about. That house should be mine. The judge didn't react to her tone. He reacted to the fact that she'd just revealed her motive in plain English. He looked at the executor. Is the property held in the trust? Yes, Your Honor, the executor said. The title is in the name of the trust. The judge nodded once. And does the trust document specify who gets that property? He asked. The executor flipped pages, careful and quick. Yes, he said. It's a specific bequest. My sister's attorney whispered urgently, Ava, stop. She didn't. My sister leaned forward, eyes hard. He told me I'd get it, she snapped. He told me I'd have the lake house. Everyone knows it. Dry humor flickered. Everyone knows the official legal doctrine of entitled siblings. The judge's gaze sharpened. Lake house? He repeated. My sister blinked. Too late, realizing she'd just called it hers out loud. The executor didn't look up. He stayed on the page. Your Honor, he said, the trust uses very specific language about that property. The judge gestured. Read it. The executor cleared his throat and read the paragraph slowly. The real property located at address shall be retained in trust and made available for Emma Carter's exclusive use and occupancy until such time as she voluntarily vacates her cells. No other beneficiary shall have a right of access, control, or occupancy. My sister's smile evaporated. What? She hissed. The executor continued reading, voice steady. Any beneficiary who attempts to occupy, interfere with, list, encumber, or otherwise control said property shall be deemed to have acted in bad faith and shall trigger the forfeiture provisions of line 12. The judge's eyes lifted from the document to my sister, and for the first time, I saw something like real fear in her, because she just said, out loud in a courtroom, "If I lose the trust, I'll take the house." And Dad had literally written, "If you try to take the house, you lose everything." Ava's attorney stood up fast, voice too polite. "Your Honor, my client misspoke. She was emotional." The judge held up a hand. "Your client is not emotional," he said calmly. "Your client is strategic." He looked at my sister. "Ms. Walker," he said, "have you attempted to access that property?" Ava's eyes darted. "No." The judge didn't argue. He asked the executor. "Sir," he said, "do you have reason to believe she has tried?" The executor didn't hesitate. "Yes," he said, "and I have documentation." My sister's attorney's shoulders dropped. Ava snapped, "That's a lie." The executor opened the binder to a tab and pulled out one page, just one. He walked it to the clerk. "Exhibit," he said. The clerk stamped it. And the judge scanned it. It was a short report, boring, official, and deadly. Property manager call log, date, time, caller. Ava Walker requesting to change the locks and asking if the property could be listed quietly. The judge's pen stopped. He looked up at Ava. "Ms. Walker," he said calmly, "did you call the property manager and request a lock change and a quiet listing?" Ava's mouth opened. Then she tried something desperate. "Yes," she said, "because she's unsafe. She's not stable. I was protecting the asset." The judge's eyes narrowed. "And you had authority to do that?" he asked. Ava's chin lifted. "I'm a beneficiary," she said, like it was a badge. The judge leaned back. "No," he said. "You are a beneficiary who is attempting to control a trust asset contrary to the instrument." He looked down again, then up. "And you filed a petition to force distribution and remove oversight," he added. He paused. "Which is exactly what line 12 is designed to punish." My sister's attorney stood again, voice shaky now. "Your Honor, we will withdraw the petition. Immediately. We ask the court not to enforce forfeiture." The judge cut him off. "I'm not interested in what you want now," he said. "I'm interested in what your client did." Then he looked at the executor. "Sir," he said, "has Ms. Carter been receiving distributions per the trust?" "Yes," the executor replied. "On schedule." "And has Ms. Walker been receiving distributions?" the judge asked. The executor hesitated, then said carefully, "She was, until last month." Ava's head snapped up. "What?" she spat. The executor looked at the judge. "I paused discretionary distributions due to concerning communications and attempted interference." Ava lunged forward in her chair, furious. "You had no right—" The judge raised a hand. "Yes," he said, "he did." Then he turned to the executor. "Sir," he asked, "why were distributions paused?" The executor flipped to another tab. "Because," he said calmly, "I received a written instruction from Mr. Carter, triggered upon his death, directing that if Ava Walker ever attempted to pressure Emma Carter through court, the corporate trustee would step in, and Ava's discretionary benefits would stop." The room went quiet again. My sister's attorney's face collapsed. My sister's voice came out smaller than I'd ever heard it. "That's not real." The executor didn't look at her. He slid one envelope forward, sealed, with a bold label, "Open upon death." One proof, visible, physical, unarguable. The judge's eyes locked onto it. "Is that instruction signed?" he asked. "Yes," the executor said. "Then the judge said quietly. We're no longer debating intentions. He looked at my sister. We're enforcing consequences. Ava's breathing was fast now, and then she made one more mistake because she couldn't stop herself. She leaned toward her attorney and said too loud, "Tell him I'll settle if she gives me the house." The judge heard it. Everyone heard it. And the judge's face hardened into something final. He turned to the executor. "Sir," he said, "prepare to read the instruction in that envelope into the record." The executor nodded, opened the envelope carefully, and pulled out the last page first. Because he knew exactly which line would end this. The executor didn't rush. He opened the envelope like it was evidence because it was. He pulled out a single-page letter on firm letterhead, signed at the bottom in a steady hand. Not dramatic, not emotional, just deliberate. He handed it to the clerk. The clerk stamped it. The judge took it and read silently for a few seconds. Then he looked up, eyes sharper than before. "Executor," he said, "read it into the record." The executor cleared his throat. "To my executor and trustee," he began, voice steady. "If Ava Walker files any petition in probate or any court to compel distribution, remove the trustee, or pressure Emma Carter regarding trust assets, you are instructed to—" My sister sat forward, breathing quick, like she could will the words to stop. The executor continued. "Immediately notify Harbor State Trust Company and transfer administrative authority as successor trustee." Ava's attorney's shoulders sank. That was the corporate trustee clause. No charm, no side deals, no let's talk. Corporate trustees don't negotiate with tantrums. The executor read the next line. Additionally, all discretionary distributions to Ava Walker are to be suspended pending court review, and any attempted interference with the real property at address shall be treated as bad faith and shall trigger the forfeiture provision referenced as line 12. Ava's face drained. She whispered, "No." The executor kept going because the letter wasn't done. Emma Carter is to retain exclusive occupancy of the property. No lock changes, no listings, no occupancy by any other beneficiary. Any effort to do so is to be documented and presented to the court. The judge's eyes moved to the property manager call log exhibit, then back to Ava. Ava's attorney stood up fast, voice tight. "Your Honor," he said, "we would like to withdraw the petition and stipulate." The judge cut him off. "Counsel," he said calmly, "you are acting like withdrawal erases the last hour. It doesn't." He looked down at the letter again. "Your client did exactly what the letter warned she would do," he said, "and she attempted to interfere with the trust property." Ava snapped, panic turning to anger. "You're all obsessed with that letter," she shouted. "It's not fair. He was manipulated. Stop," the judge said, sharp. He turned to the drafting attorney's filing already in the record. "Executor," he asked, "did Mr. Carter draft this letter with counsel?" "Yes," the executor said. "It was prepared with his estate planning attorney, signed and witnessed." The judge nodded. Then he asked the question that hurt most. "Ms. Walker," he said, "what proof do you have that this trust is obviously yours?" Ava's mouth opened. Nothing. Her attorney tried to answer for her. "Your Honor, my client's belief is based on the years of support she provided." The judge held up a hand. "Belief is not proof," he said. Then he looked at the executor. "Do you have the trust schedule?" he asked, showing the assets and who receives what. "Yes," the executor said, flipping to a tab. The judge gestured. "Read the relevant portion." The executor read the summary, distributions, percentages, and the specific bequest language giving me exclusive occupancy of the lake house. It was clean. It was formal. It was the opposite of my sister's "everyone knows." Then the judge leaned back and exhaled once. Classy and lethal now. Pure procedure. "Here is what I'm doing," he said. "The petition is denied in full. Line 12 is triggered by the petition and by the attempt to interfere with trust administration without documented cause. Ms. Walker's interest is reduced to $1, subject to confirmation by written order. Harbor State Trust Company is directed to assume administration as successor trustee immediately. A no-contact order regarding trust administration is entered. Ms. Walker may not contact the property manager, list the property, attempt lock changes, or contact financial institutions about trust assets. Attorney's fees and costs are reserved, but likely. Ava's attorney's face went pale at $1. Ava's face went empty, like her brain couldn't process that money could disappear because of one line. She tried one last move. Then I'll appeal, she whispered. The judge didn't even flinch. You can, he said, but the documents will not change. He looked at the bailiff. Bailiff, he said, I want a copy of today's order served on the property manager and the corporate trustee by close of business. The bailiff nodded. Then the judge looked at me. Ms. Carter, he asked, do you want exclusive occupancy enforced? Warm and relatable, steady. Yes, Your Honor. The judge nodded. Granted, he said. Ava made a small sound, half laugh, half sob, then said quietly, Venomous, you're going to regret this? The judge's gaze snapped to her. Threats, he said, are not going to help you today. Then he did something that really mattered. He looked at the executor. Executor, he said, I want the property manager to be instructed to refuse lock changes or listings without written authority from the corporate trustee. Yes, Your Honor, the executor replied. The judge nodded once, and then he leaned forward and said the line that made the room go still again. Ms. Walker, he said, you are not losing because your sister outsmarted you. He paused. You are losing because your father anticipated you. Ava's face twisted. Because she couldn't insult a clause. She couldn't argue with certified mail. She couldn't charm a corporate trustee. And she couldn't bully a judge who had the letter in his hands. The judge's gavel came down. Adjourned. But it wasn't over yet. Because outside the courtroom doors, as we stood up, the bailiff stepped toward Ava. Not aggressive, just official. Ma'am, he said, the judge also ordered you to provide your contact information for service and to confirm you received notice. Ava rolled her eyes. Then she did the dumbest thing possible. She muttered, under her breath, loud enough for the bailiff to hear, Doesn't matter, I already changed the locks. My stomach dropped. The executor's head snapped up. And the judge, who hadn't even left the bench yet, looked up sharply. Ms. Walker, he said, voice suddenly dangerous, what did you just say? Ava froze. Because she just admitted, on the record, that she violated the very clause that ended her. And now it wasn't just probate consequences anymore. It was contempt. For a second, my sister didn't breathe. She stood there in the aisle like the sentence had slipped out of her mouth on autopilot and she couldn't pull it back in. The judge's voice was calm, but it had that edge you don't ignore. Ms. Walker, he said again, repeat what you just said. Ava looked at her attorney like he might teleport her out of the room. He didn't move, because he couldn't. Ava swallowed, then tried to laugh it off. I didn't mean, she started. The judge cut her off. I didn't ask what you meant, he said. I asked what you said. The bailiff stood still beside her, hands folded. Not threatening, just present. Ava's jaw tightened. Pride beat survival, again. I said, she snapped, it doesn't matter because I already changed the locks. Silence. Not awkward silence. Courtroom silence. The kind that's basically the sound of consequences loading. The judge leaned forward. On the trust property? He asked. Ava hesitated a fraction of a second. Her attorney whispered, urgent. Stop talking. Ava talked anyway. Yes, she said. I had to secure it. The judge's eyes narrowed. Secure it, he repeated, almost gently. From the person with exclusive occupancy. Ava's face flushed. She wasn't even there. The judge didn't argue. He turned to the executor. Executor, he said, did you authorize a lock change? No, Your Honor, the executor replied instantly. Did the property manager authorize it? The judge asked. The executor shook his head. No. The judge nodded slowly. Then he looked at the bailiff. Bailiff, he said, I want this handled now. Ava's attorney finally stood, voice trembling. Your Honor, this is a misunderstanding. The judge's gaze snapped to him. Counsel, he said, your client just confessed to interfering with trust property after being warned, after filing in bad faith, after being read the clause. He turned back to Ava. Ms. Walker, he said, calm and cold, you are in contempt of this court's orders and the trust instrument. Ava's face went pale. What? No. The judge raised a hand. I'm issuing an emergency order, he said. You will provide the name of the locksmith and the method of entry, right now. Ava shook her head, trying to hold on to control. I don't have to tell you anything. The judge's tone didn't rise. It got quieter. Yes, he said. You do. He looked at the clerk. Clerk, he said, note contempt. Prepare a written order requiring immediate restoration of access to Ms. Carter and service on the property manager and Harbor State Trust Company. Then he turned to the executor. Executor, he said, contact the corporate trustee immediately. I want a representative on the phone within the hour. The executor nodded and stepped out, already dialing. Warm and relatable moment. My hands went cold, not because I thought I'd lose, because I suddenly pictured myself getting to the lake house and not being able to open the door. Dry thought. Ava really heard $1 and said, cool, I'll break in. The judge looked back at my sister. Who did the lock change? He asked. Ava's lips pressed tight. The bailiff took one step closer, not menacing, just closing the distance. Ava cracked. Fine, she said, voice sharp. It was Lakeside Locksmith. The judge didn't blink. Phone number, he asked. Ava rattled it off, furious. Method of payment, the judge asked. Ava hesitated. Too long. Method of payment, the judge repeated, slower. Ava's voice dropped. My card. The judge nodded once. Then he said the sentence that ended her last illusion of control. Good, he said. That's a traceable transaction. He turned to the bailiff. Call the sheriff's civil division, he ordered. We are enforcing an emergency access order on a trust property. Coordinate with the corporate trustee and property manager. Ava's attorney's face collapsed. Ava whispered, You can't do this over locks. The judge looked at her like she was a child who'd just broken a window and tried to argue physics. I can, he said, because it's not over locks. It's over defiance. 2 hours later, I was in my car driving toward the lake house with the executor on speaker and a corporate trustee rep on the other line. Harbor State Trust Company didn't sound emotional. They sounded like a machine designed to end chaos. Ms. Carter, the rep said, we have assumed administration effective immediately. We've instructed the property manager to deny any requests from Ms. Walker. We're coordinating enforcement. The executor added, and I have the locksmith invoice already. Ava paid for it. Same name, same time. Receipts, again. When I pulled up to the house, the place looked exactly the same from the outside. Same trees, same quiet, same porch light. But the lock was new, shiny, wrong. A sheriff's deputy and the property manager were already there waiting. The deputy looked at the papers, then at me. Are you Emma Carter? He asked. Yes, I said. He nodded and held up the order. This says you have exclusive occupancy, he said. We're restoring access. The locksmith arrived 10 minutes later, nervous, apologizing, hands shaking. I thought she had authority, he mumbled. The deputy didn't yell. He pointed at the order. This is what authority looks like, he said. The locksmith replaced the lock again. Right in front of me. And when he handed me the keys, it felt like my lungs worked for the first time all day. The property manager looked at me, embarrassed. She called me 3 times, he admitted. I said no. She did it anyway. I nodded. Now you have the corporate trustee's instructions. He nodded back. Yes, from now on, everything goes through them. That's what Ava never understood. You can bully people when things are informal. You can't bully a corporate trustee. That evening, back in court, the judge took a brief status update. Corporate trustee confirmed administration. Sheriff's division confirmed enforcement. Property manager confirmed compliance. And the judge looked at Ava one last time. Ms. Walker, he said, you had an opportunity to walk away. Ava sat there stiff, mascara just slightly smudged, more from rage than tears. The judge continued, voice calm. You chose to violate the trust and this court's authority instead. He paused. Your interest remains $1, he said, and I'm imposing sanctions for contempt. Ava's attorney didn't even try to speak. He just stared at the floor like he was memorizing regret. The judge looked at me. Ms. Carter, he said, your occupancy is enforced. Your trustee is in place. Your sister is restrained from interference. I nodded. Thank you, Your Honor. He nodded back once, no warmth, no drama, just closure, gavel, adjourned. When I finally walked into the lake house that night, it didn't feel like a victory parade. It felt like peace returning to the room. I set my keys on the counter and stood still, listening to nothing. No threats, no lawyer voice, no, obviously. Just quiet. I didn't want revenge, I wanted it to stop. And the thing my sister couldn't accept until she learned it the hard way was simple. Dad didn't leave her a fight. He left her a line, and that line closed the door.